What are the legal limits of employee-free speech on social media? Imagine sharing your thoughts online and wondering if your boss can see or even punish you for what you post. Social media has become a big part of our lives, but it also raises questions about what employees can say without risking their jobs. Let's look at what the law says about free speech on social media in the workplace. For workers at private companies, the First Amendment does not protect their social media posts. Private employers can set rules about what employees can or cannot post. If a post violates company policies, like being offensive or discriminatory, the employer can discipline or even fire the employee. This is because private companies are not bound by the First Amendment, which only protects speech from government restrictions. However, employees still have rights to discuss workplace issues or organize for better conditions, as protected by labor laws. When it comes to government workers, the First Amendment does offer some protection. They can speak about public concerns on social media, but these rights are not unlimited. Courts weigh the employee's right to free speech against the government's need to keep the workplace running smoothly. If a post is disrespectful, unprofessional, or disrupts work, the government employer can discipline the worker. For example, if a public employee posts something that harms their department's reputation or interferes with their duties, they could face consequences. Many employees mistakenly believe their social media activity is private. But most posts are visible to the public or semi-public, and employers can monitor or respond to posts they see. Even private posts can lead to discipline if they become public and affect the workplace. Employers have a valid interest in protecting their reputation and ensuring a respectful environment, which can justify limits on social media speech. To stay safe, employees should review their company's social media policies and employment contracts. Public employees should be cautious about posting controversial opinions, especially if their role involves public trust. Private employees should avoid offensive, false, or discriminatory posts that could violate workplace rules. Employers should clearly communicate their policies and make sure they follow labor laws protecting employee rights to discuss work issues. In the end, free speech on social media is limited by the employer's right to keep the workplace respectful and lawful. Private workers have fewer protections, while public employees have some First Amendment rights that are balanced against workplace needs. Social media activity is not private, and both sides should understand these boundaries to avoid conflicts.